Hey everyone, welcome back to the channel. Today we're diving straight into Judge OLSAR's courtroom, where we meet a classic case of a country bumpkin sovereign citizen who genuinely thinks he can retry his original case just because he violated his probation. Spoiler alert, that's not how the legal system works. Let's jump right in.
Okay, we are on the record in file 21-20513-FH, People versus Robert Joseph Matson. We are here today for a hearing on a probation violation, and we are proceeding today by video conference. Mr. Matson is present from the Lenawee County Jail. Mr. Matson, my court notes indicated that at the last hearing, you waived your right to be represented by an attorney. I am required to advise you at all stages of the proceeding that you do have a right to be represented by an attorney, and if you can't afford an attorney, the court will appoint one for you at public expense. Do you understand that?
I don't think you'd be violating your oath of office, Your Honor, by allowing me to the right to a fighting clause.
Wait, are you claiming a fighting clause situation like Wolverine? Or a fighting clause like some angry Santa? Either way, your fantasy world doesn't override reality. The judge's oath doesn't bow to your delusions. And no, you're not invoking any clause today, fighting or otherwise.
Sir, I didn't ask you about any of that. I asked you if you understand.
I will, however,
Mr. Matson, don't interrupt me. The question I asked you is whether you understand that you have the right to be represented by an attorney.
I do understand I have a right to be represented by an attorney or not. Yes, sir.
Okay. You've previously waived that right. As I said, I have to advise you that at every stage of the hearing. So I have to ask you again, would you like to be represented by an attorney at this point?
As I started to say, Your Honor, I don't want the representation. However, I will use the help of handling paperwork due to my means here and having access to certain things in paperwork. I will use your court-appointed attorneys just to help with some paperwork.
That's not what a court-appointed attorney is for. They can either represent you fully or you can go solo. Acting as standby counsel doesn't mean they're your personal errand runners. They advise you on procedural stuff, yes, but they aren't filing your nonsense paperwork or running your imaginary errands.
Okay, so you don't have a right to have the public defender's office do your paperwork or handle any of that. You have the right to have them represent you or not represent you. So that is your choice.
Not represent me, that's fine then.
All right. So you've previously been arraigned on the probation violation. Do you know how you want to proceed? So your options are you can plead to it if you want, which means you'd be admitting guilt. The other option is that I can set it for a hearing and we can have a hearing on the matter, and then I'll decide based on the evidence submitted at that hearing.
Your Honor, all due respect, I wish, are you working under oath of office today, sir?
Sir, I'm not going to answer these questions or deal with this. We've dealt with you before, and your sovereign citizen arguments, I've rejected them all.
Citizen.
Sir, do not interrupt me. Do you want to have a hearing or do you want to plead?
I'll take your silence under your oath, Your Honor.
Okay. Do you want to have a hearing or do you want to plead?
I want the hearing. I want to go to trial. I want to go within 90 days to a trial or sooner.
All right. So Sierra will need about a 1-hour hearing on a probation violation.
As well as I'd like you to have the arresting officers that arrested me on that day. I would like their sergeant to be dressed in uniform and at that trial on that day as well, please.
Here's the deal. You were arrested for violating probation. That means a judge signed a warrant to have you picked up because you didn't follow the orders you agreed to after your original conviction. Simple as that.
Now let's do it on Monday then. We'll do it on Monday, April 8th, I'm sorry. Monday, April 8th at 3:30. Mr. Mattson, do you want to be present in person for that hearing, or do you want to do it by Zoom?
It doesn't matter. Judge, whichever is best for the courts, be fine with me.
All right, I think it will go more smoothly if you are here in person, so we will have you in person here from the jail.
All right, exactly what the hearing is going to be on that day?
So you've been charged with a violation of the terms of your probation.
Yeah.
For failing to report. So the hearing is going to be to determine whether or not you failed to report.
Okay, so it's going to be the trial that day.
Correct.
Okay, can I have the state police sergeant there at that trial?
What state police sergeant?
The state police sergeant of the arresting officers on the night of my arrest.
Who are the arresting officers?
I don't remember the exact names. But any state police sergeant in uniform would do.
Why do you want any state police sergeant to be present at the trial?
Just to show how arrests are made, and why they're made, and how they do the determination how they bring people into jail.
Well, how is any of that relevant to whether or not you violated the terms of probation?
I believe there's a lot of relevancy there.
Honestly, sovereign citizens keep redefining what dumber than a bag of hammers really means. You failed to check in with your probation officer. That's a direct violation of the agreement that let you serve your sentence outside of a jail cell. Probation isn't a right, it's a privilege, and maybe it's time you remembered that.
I don't see where any of it's going to affect the courts in any way, shape, or form.
All right, so the issue that the court is going to determine has nothing to do with things that happened during your arrest. The issue is whether or not.
No, it's not about the arrest. It's about the arrest for the violation of probation as well.
All right, the only issue before the court that day is going to be whether or not you reported. So your arrest doesn't have any relevancy to that. So I'm not going to.
I beg to differ, Your Honor. I beg to differ because the jury is going to be a jury of my peers, and at this time,
sir,
you're not going to have a jury of my peers.
Sir, there's not going to be any jury. You're not entitled to a jury trial on a hearing about violating your probation.
I'm sorry, I misunderstood. I'm pretty sure that last time I spoke to you, you said that I had the right to a jury trial for determining if I was guilty for a violation of probation.
I've never seen you on this violation of probation.
I've seen you, or I've seen you just the other day, last week.
And just like that, our self-proclaimed legal genius manages to violate probation in a single week. This is why courts are serious about check-ins. There's no, I'll get to it when I feel like it with probation. Miss the deadline and you pay the price, end of story.
No, you didn't. A different judge conducted that hearing.
You're Michael Olsaver, aren't you? There was Dan Sloan, and then there was you. I've seen both.
You did not see me last week.
I did.
And so you're not entitled to a jury trial on a probation violation. So again, we will have you back in person on.
Well, hold up then. So if I'm not entitled to a trial to determine if I'm guilty or not, this is a criminal court, isn't it?
It's a criminal court where you have already pled guilty to a felony and been placed on probation.
Because I was at risk of dying in this.
I've muted Mr. Mattson's device because he continues to interrupt me and not let me finish what I'm saying. Mr. Mattson, I was saying that this is a criminal court wherein you have pled guilty to possessing a controlled substance, and you were placed on probation as a result of that. Your sentence was to be placed on probation. Subsequent to being sentenced to probation, there was an allegation that you failed to report in accordance with the terms of your probation. That is an alleged violation of probation. There's no right to a jury trial for a violation of probation, so the court will conduct.
Let me speak to.
I've muted Mr. Mattson again because he unmuted himself and interrupted me. We will have you back on April 8th at 3:30, Mr. Mattson. This hearing is concluded.
All right, that wraps it up. Looks like we'll be seeing Joe Dirt and his iconic sovereign mullet back in court soon. Thankfully, he's already in custody, which means we might catch the next episode on Zoom Court and here on the channel. If you enjoyed the chaos, hit that like button. Didn't enjoy it? Smash dislike. Either way, leave a comment, subscribe, and turn on notifications so you never miss these courtroom adventures.